In this, the first section of our MAC Project Legal Literacy webinars, I'm going to try and give you an overview of the scheme for supporting vulnerable children and for protecting vulnerable children that we have in this country. This webinar is best viewed with a copy of the MAC Project PowerPoint slides in front of you. These can be downloaded from the Central England Law Centre website. Essentially, in this country, we have a series of steps for supporting vulnerable children. These start at early help, progress to children in need support or Section 17 support, so called because the powers, the provisions come from Section 17 of the Children Act 1989. We then move up the steps to support that can be provided to looked after children, and finally to support that can be provided to children in care. Now, the terms looked after and children in care are sometimes used interchangeably, but they do mean something slightly different. So we will look at that in a bit more detail when we move to the later section on support for looked after children and children in care. If somebody has been looked after or in care, so if they have been supported on the third or fourth of those steps being early help, children in need, support for looked after children, children in care. So if they've been supported in those later two steps, they may have an entitlement, a right to support from the local authority as a child leaving care. Now, when we're thinking about young mothers who are themselves looked after or who have been, we're looking at young women who already are sitting on the highest levels of these steps. So either they're looked after or they're in care, or they've now become care leavers. But when we think about their children or their babies, those children could sit anywhere on the steps, so anywhere in our scheme for supporting and protecting vulnerable children. The local authority might assess that those children have a need for early help support or child in need support, Section 17 support. Alternatively, they may decide that those children should become looked after or need to be taken into care. Eventually, those children could also, if they do become looked after or they do end up being taken into care, they could eventually have an entitlement in their own right to support as care leavers. A very important thing for you to remember when you're faced with a situation where young women and their children that you're working with are being assessed by the local authority, or the local authority is investigating whether that family might need support. A very important thing to remember is that everyone in this country, so including our mums and their children, have a right to respect for private and family life under Article 8 of the European Convention on Human Rights. And what Article 8 says is that everyone is entitled to have their private and family life respected, and that there should be no interference in that right by a public authority, which would include local authority social services, unless that interference is lawful and is necessary. To be lawful, the local authority social services would only be allowed to intervene in the private and family life of mothers and children if they were doing so for one of the following reasons. So in the interests of national security, public safety, economic well-being of the country, for the prevention of disorder or crime, for the protection of health or morals, or, and this is the key one in this context, for the protection of the rights and freedoms of others. That means that a local authority would be permitted to interfere in the private and family life of a mother and child if they were doing so to protect the child. However, to be lawful, and to be necessary, a local authority also need to consider how proportionate a response that they undertake is, i.e. they must do the least intrusive thing that they can do in order to protect the child for that to be necessary, for that to be lawful. That means that local authority social services must constantly have a balance in mind when they're looking at the rights and freedoms of the mother and the rights and freedoms of the child, and they're making decisions about what's going to be right for a particular child. The balance will lie somewhere different in each case, and it's always going to depend on the individual circumstances of that family, what's happening to that particular child, as to whether what the local authority is proposing to do is necessary in that particular case. If we think back to our different steps of support, so back to early help, child in need support, support for looked after children and children in care, and then support for care leavers, it's clear that the higher up those steps we get, i.e. the closer we get to support for looked after children and care leavers, the greater the level of interference the local authority social services is exercising in the private and family life of mum and her child. The European Court of Human Rights has found that the scheme that we have in place in this country for supporting vulnerable children and for protecting them, those different stages that we've talked through, that scheme as a whole is lawful, is consistent with the European Convention on Human Rights. However, that doesn't mean that the individual decisions of local authority social services departments, when they're making decisions about what's going to happen to a particular mother and her child, that those decisions will also be lawful. So in every decision that is made by a public authority, Article 8 needs to be applied. And in some situations, a local authority's actions might go beyond what is necessary to protect the rights and freedoms of the child. And where a local authority's actions go beyond what is necessary, they would not be compliant with Article 8. In order to get the balance right between the rights and freedoms of mother and child, the local authority needs to look at providing appropriate support to both at an appropriate time. In the view of the MAC project workers, we think that if mum has access to the right support at the right time, that the need for protection of her child might reduce, might diminish. It's up to the local authority social services to decide what the right support is and when it should be provided. Now, unlike most other areas where public bodies are making decisions that affect private individuals in a very profound way, there is no tribunal, no appeal from the decisions of social services as such. So, for example, if a decision is made which affects you negatively at work or in relation to your immigration status or your benefits, there are tribunals that you can go to, an employment tribunal, an immigration tribunal, a welfare benefits tribunal. There's no tribunal that deals with the decisions of the local authority social services in this country. That means that the only court that you can go to argue about the local authority's treatment of an individual affected by the decisions of social services is the High Court or the Administrative Court in judicial review. We'll talk about judicial review and what the criteria are for bringing a judicial review and what that means in a later section of this series of webinars. So we've talked about the scheme, the different stages, and what we're going to do in the rest of these webinars is break down what each of those stages mean. So we'll talk through early help support, how to access it and what it is. Section 17 support, child in need support. We'll talk about support for children in need through accommodation under Section 20 of the Children Act, as well as support for them through Section 17 of the Children Act. We'll also talk about support for looked after children, children in care, and we'll go on to break down the support that can be accessed by children who are leaving care. And it's hoped that if young people are able to access support at the right level, at an appropriate point on those steps, that actually they can be helped to move down those steps, or at least to stay on the same step. So it's important to remember that whilst we have a series of steps, we don't necessarily always need to progress up them, that it's possible to de-escalate needs or to keep needs at a certain level, to maintain them at a lower level if the right help is put in place. And this series of webinars is really all about helping advocates to understand what each of those areas is and what can be accessed at each stage, so that hopefully they understand the range and the wealth of support that can be accessed, which might mean that it doesn't become necessary for young people to progress up those steps towards child protection where they risk losing their children to the care system.